Good afternoon. My name is Ala McCoy. I am Director of Startup Support at the University of Maryland's Ventures. And I'd like to extend a warm welcome to all of you who joined us today for the next installment in Startup Fundamentals Workshop Series. Both live webinar audience and those watching a recorded version on our StartupUMD YouTube channel. This workshop series is offered by Ventures with collaboration from MTech at the Clark School of Engineering and Ingman Center for Entrepreneurship at the Smith School of Business at the University of Maryland, of course. To everyone attending the live session, please feel free to submit questions using the Q&A function. You can usually find it at the bottom of your screen, but it depends on your Zoom setup. This session is recorded, will be posted to our StartupUMD YouTube channel, so you may submit your question anonymously if you would like to. So today's session is designed to arm you with the critical legal insights every small business owner needs to navigate the complexities of today's business world. I'm very pleased to welcome our speaker today, Greg Tinch, who will break down the complexities of the legal landscape. Our presenter, Greg Tinch, is owner and principal of Tinch Law Firm, located right here in College Park. It's an intellectual property boutique helping founders and small businesses protect ideas and brands since 2018. So thank you, Greg, for spending your time with us today. I am going to turn off my mic and my camera, leave the mic to you, and to everyone in the audience, please do submit those questions.
All right. Hi, everyone in the audience. Thanks for joining the webinar. Ala, thanks for the invite. I'm an alum of UMD, so always happy to, show my support and share what I know. Hopefully it helps people move forward and grow and chase their priorities down. So as Ala mentioned, my name is Greg. I'm an IP attorney. I think in my practice, I help people think through, founders and entrepreneurs, business owners, stakeholders think through the strategy and tactics around how to grow and scale their business from a business law IP perspective, principally. And we're just gonna, let me move the slides here. Sorry, I got two screens going because I thought Zoom was going to let me do the PowerPoint presenter view, but it didn't. So I'm manually doing it. Sorry if there's a little lag here. I'm manually coordinating. So I guess the definition part I will start with. Intellectual property. If you're not aware, or if you are like unfamiliar with that idea, intellectual property is a concept within business law generally, and it refers to patents, trademarks, copyrights, and trade secrets. Oh, also, sidebar, not sidebar. I need to give the disclaimer that this is not legal advice, it's just an educational webinar. And to be a client of my firm, Tinch Law Firm PC, we need to have a signed engagement agreement. So the firm is available to hire, but we'll need to schedule a consult, lay out the scope of the engagement first. There will be a slide at the end with a Calendly link. If you want to learn more and schedule a consultation, you can do that. Back to the slides. So IP is generally patents, trademarks, copyrights, and trade secrets. And intellectual property, if you kind of like, not the etymology, but if you break that down, it's like these intangible ideas, but they have a proprietary value for your business venture. You can basically like reduce them under the law. You can reduce them to tangible things that can show up on your business's balance sheet, attract investors, have a real tangible value to your venture. So this slide, why does it say tactics versus strategy? Well, in my practice, I would say I help business owners strategize around like risk and specifically how to de-risk their venture and their specific operations. So there's the strategy, which is the like high level plan that you want to execute, and then there are the tactics, which are the specific um, like plans, maneuvers, actions that you're going to undertake to implement the strategy. So I would generally say, you know, we high level, we think about strategy, we think about where we're going to go, big picture plan, and then we come up with a set of tactics later to implement that strategy. So I think that's the order. My goal with this kind of like overview survey of IP business law is to help you, at a high level, like understand strategic best practices and um, also to understand like some of the tactics that are accessible to you, some of the tactics that are not accessible to you, but just to understand like what's what and what type of assets you can own and what are the decisions that you need to confront before you can really like move forward, scale your business, get investors, whatever your growth strategy is. So, sorry, advancing my slide on the second screen here. So, our hypo, this is the second time Olive's invited me to give a presentation like this. And the first time it was kind of a lecture, which when I was an undergrad, lectures kind of made me fall asleep. So I decided, okay, let's switch it up. I think it's necessarily got to be part lecture, but I'm going to invite some audience participation here. So maybe you could just drop it in the Q&A. We will figure out what works. And also, um, I'm happy to pause and field questions as we go. I think there's an hour allotted for this presentation. I don't have enough slides to fill up an hour, so I'm happy to take some detours and discuss things as they come up. So here's my hypo for us to think through as we dive into these topics around like business law IP. So you are working on a tech startup called Solar Flare. Solar Flare focuses on renewable energy tech, specifically solar. Of course, it's in the name. You, I guess we could say you're the CTO, and you invent this apparatus called the SunPower tile, which is a sleek, innovative solar tile that integrates seamlessly with existing roof materials to generate solar energy while maintaining the aesthetic appeal of traditional roofing. These tiles are designed to be both highly efficient and durable, capable of withstanding various weather, inclement weather conditions. So your goal is to scale this venture, bring this product to market, and see what kind of commercial success you can get. The first question that you're going to have to confront is, what type of entity is Solar Flare going to be? So I think you're happy with the name Solar Flare. You're happy with the SunPower tile, or at least that's the working title. But now that you're going to grow and scale, you have to pick an entity choice. So what do I mean by entity? Well, under the law, a business is generally separate from me, Greg, or Allah, or any, member, shareholder, investor of that entity. So, this is kind of like the legal underpinnings of what was that case? The Supreme Court, Citizens United. They said corporations have the right to speak. They're separate entities that can have their own life, essentially. And you know, the upshot is that for most entities, like the ones you're familiar with, like corporations, LLCs, partnerships, etc., if something happens, liability for the debts, obligations of the entity aren't inherited by the shareholders or the members or the people behind the organization. So let's say that solar flare, your sun power tile, one of them explodes, or there's a manufacturing defect where they just explode and burn up people's houses. There's a class action suit. The assets of solar flare are about 1 million, but you owe the survivors of these suits 5 million. You've exhausted all the appeals. So you're in a shortfall of $4 million. Solar flare can go bankrupt, and the claimants can't pursue you personally for the 4 million shortfall, right? So whatever inventory, cash, assets the corporation has, right? You sell them off and do your best to fulfill the judgment, but after that, you walk away and your investors walk away. So that's really why investors feel safe to give you or any venture capital, principally because they're limited from personal liability if the venture were to fail. This doesn't follow for sole proprietorships. So sole proprietorships are an entity. However, they don't carry the limited liability shield. So I would say first thing, especially for a company like Solar Flare, organize an entity. Don't operate as a sole proprietorship. So sole proprietorships, people end up in them because they're easy. They have no formalities. You don't have to file anything. You can just simply, hang out a shingle and go. It is recommended if you want to grow and build scale, you should choose an entity, file your formal documents with Maryland State Departments of Assessment and Taxation. Delaware is also a popular state to organize, but whichever state, file your formal documents, track the compliance regimes, and organize your entity. So the next choice is you've chosen to form an entity. The next question is, which entity are you going to pick? I think the common ones are limited liability companies, corporations, and partnerships. So let's leave partnerships to the side. I don't see a ton of those. I don't think that's going to apply here. I think LLCs and corporations are the most popular. LLCs are commonly single member LLCs, right? Like it's just you're bootstrapped. You can file the paperwork. There are formalities, but relatively low formalities. It's easy to set up. But I would say, depending on your growth strategy, specifically if your growth strategy involves trying to attract investors, you should really consider corporations. Why do I say that? Well, both corporations and LLCs share the liability shield. LLCs and corporations are taxed differently. LLCs generally have pass-through taxes where the revenue of the business, like the profit or loss of the business, flows through to your personal return. So, you have business return, business return, personal return, but how the business does shows up on your personal return. That's pass-through tax. Generally, corporations aren't taxed like that. You can make an election so that you are taxed like that, but that's not the default rule. Corporations have perpetual existence, so they will exist in perpetuity, ostensibly after you're gone. Investors are, I believe, more apt to invest in a corporation because they can give capital, but they don't have to be a member. LLCs have members. So that's how you join an LLC and participate in the operations of LLCs versus corporations, as I'm sure you know, have shareholders. So in the formational document, which is the for corporations, it's the articles of incorporation is what you'd see on SDAT site. Charter is just shorthand that you may hear when people say charter. They're talking about the formation document. But in any event, the charter sets out what classes of stock are available, and there's stock that has voting rights, there's stock that doesn't, there's stock that has priority if the company were to be liquidated. But there's different classes of stock to allow investors to invest without, impeding your ability to manage the company or watering down your equity stake too much. And the last main difference is federal tax reporting. The main difference between LLCs and corporations is federal tax reporting. So the IRS doesn't recognize LLCs, they're creatures of state law. The IRS does recognize corporations and partnerships. So when you do your federal tax reporting for this entity, you'd have to pick either a corporation or a LLC. So it's just one less thing for your tax accountant to do if you're already a corporation. Glancing at my notes to see if I missed anything. I mentioned that you can, as a corporation shareholder, you can be taxed as a pass-through entity. You do that by filing an S corp election with the IRS. That changes your tax treatment, and that's something you can do as an alternative to like a sole member LLC or a small LLC as you grow and build scale.
Greg,
Uh,
there's a question on this subject. Could I read that out to you?
yes, please.
Um, I'll rephrase it just a little bit. So because you are the CTO, there presumably is already CEO, a co-founder as well. So should the setup be a C Corp because there are multiple founding people?
C corp as opposed to S corp.
No, I think LLC. I think that's what they're
Oh,
referring.
C corp as opposed to LLC. I mean,
That's, well, correct me if I'm
yeah,
wrong. Whoever asked the question.
I would say the LLC C corp question really turns on like growth strategy. Like, are you looking to attract outside investor capital, and are you willing to trade equity for it? Like, if your growth strategy is like, you could apply for an SBIR grant and get non-dilutive funding and build a prototype to go to market that way. So I don't see any reason why you necessarily need to be a corporation there. Your operating agreement for the LLC, you could just specify like who does what and how, you know, revenue profits or profits of the profits of the LLC are distributed. So I, I would say it turns mostly on like growth strategy and if you're looking for investors. But I think in fact investors generally expect a corporation and to get shares in the corporation. But that's yeah, that's what I think. I hope that actually answers the question though.
Yeah, thank you.
Okay. Is there more Q&A? Because I know this gets dense, so I'm also looking for points to come up for air.
There is a question here, but I don't know if it's appropriate for this section. I'll read it and then we can either answer it now or maybe you might have it down the road. How do
Okay, sure.
nonprofits 1C3 operate?
Sorry, one more time.
How do nonprofit 501c3s operate?
Yeah, So that is a tax selection as well. I think all the same considerations apply. Yeah, I think all the same considerations apply. Um, I believe you could still pick a LLC or like however you organize under the state law. You can use any, sorry, the like Maryland law authorizes certain entities, authorizes the State Department of Assessments and Taxation to recognize certain entities like sole proprietorships, LLCs, LLPs, I think LLLPs, professional corporations. There's a whole long list. And then, you know, you as a individual have to pay tax, and then also the business has to pay tax. So for your like reporting for tax purposes, that's where you make the election. The rules for not-for-profits are under that 501(c)(3) section of the tax code. So I think your like state law choice of entity is it doesn't necessarily depend on the fact that you would like to be a 501(c)(3). I think you should, I think you have to think about like how do you want to manage the business? So a LLC is really managed by the members, whereas corporations have like a board of directors. Um, and the board is not necessarily paid, but yeah, I think the governance, like how you want the governance to work, is actually important for that decision. I know I didn't talk a ton about that. Um, I'm just trying to condense everything into an hour, but yeah, I hope that answers.
Yeah, thank you.
Okay. More questions?
I don't see any more questions, so maybe we can.
Okay. Then so that was I guess that's the general business law consideration, at least like the formal piece with Maryland SStat or the um, Delaware Secretary of State. That's the formal thing, getting your entity recognized. Um, Now we're going to go a bit into IP considerations for business law IP considerations. So we've got this logo here for solar flare, and we've got the name solar flare, and we've got even a SunPower tile. So we're going to go into the marketplace and sell these things. How do we protect the Dolly made this, but how do we protect our brand as we go out there and sell? The mechanism to protect your brand under state and federal law is trademark. So trademark tells the consuming public the source of your goods and or services. I mean, the gold standard you're going for is, sorry, let me approach this more slowly. So you can register a trademark with Maryland. It's the Maryland Secretary of State's office who registers trademarks in Maryland. I believe every state in the US has a Secretary of State who will register a trademark under that state's law. Alternatively, you can file an application to register your mark with the United States Patent and Trademark Office, shorthand USPTO. You file this one application, you pay one fee, and if the application is examined and allowed and your mark registers, that grants you trademark protection for your brand and your marks in every US jurisdiction. So, track one is you'd have to file in every individual state. And by the time you filed in all 50, it would be quite a lot. Or you can pay one registration fee and get protection in every state. So this is why the preferred track is to file an application with the PTO. The components of your trademark registration. So one is the mark, right? When you file an application, you have to file a drawing of your mark with it. So, it could be this for solar flare, or it would be the actual characters solar flare, however you want to spell them. Trademark subject matter eligibility. If you've seen that Southwest or the Southwest commercials, they have that ding. That's trademark eligible. Whatever you believe holds out your business and makes your business distinct from competitors. So, we have this word, or this word mark, solar flare, and we have this design. What do we think our strategy should be around these two? I guess I put it in the slide. You can actually file 2 applications for the design and for the word mark. And I would recommend if you have the capital to do that, I think that's the best strategy. At a high level, I think the way you have to think about your IP asset portfolio is there are different laws that cover different assets. And if you have a situation where you need to enforce an asset, it may not fit tidy into the Copyright Act or the Lanham Act, which authorizes trademarks, or the Patent Act. So, I think ideally you want to accumulate as many assets as you're subject matter eligible for. And if there is a problem, then you have all these different avenues to attack it. You can raise all these different counts and say, well, look, if they violate on the Patent Act, they violated on the Lanham Act. If they violate on the Lanham Act, they violated on the Copyright Act. So, you can diversify your portfolio and just give yourself more avenues of recovery, or to stop infringement, stop a competitor who's trading on your IP. I'm glancing my notes on the other screen here to make sure I covered everything. So once a trademark is registered, the life of the trademark. So you have a subsequent filing due between years 5 and 6, and you have a filing due at year 10, and every 10th year thereafter, or every 10th anniversary thereafter. But assuming you keep up with those PTO compliance requirements, your trademark can exist perpetually. Also, one additional benefit of trademark registration on a federal level is that once you file an application, you don't even have to get registered, but once you file the application into the system, every time the law office looks at a subsequent application, yours is in the universe of marks that they're checking against, right? And they're looking for marks that may be confusingly similar to yours. So everyone else's application is examined in view of yours. So you don't even necessarily have to be like actively defending the registration. There's some passive defensive benefit there from just putting your mark into the system. I think I covered all the high level trademark ideas, but if there's questions, we could talk about them.
There's a question where to start with the trademarks, and can you share the links? We can do that after the workshop, or I can post some links, USPTO links there, if you would like me to.
Okay. Yeah, we could do that. I'll just quickly say the PTO's website is uspto.gov. So they've actually published a wealth of resources to make like IP generally more accessible. So the Patent and Trademark Office, I mean, it's in the name, they administer patents and trademarks. trademarks. They have a series of workshops actually to kind of train you up on the process from like conceiving the brand idea to searching the trademark register for or to the trademark database and register for marks that may be similar to your proposed mark. They tell you a bit about filing an application. They tell you about the subject matter eligibility, the legal standard for like approving or not approving a trademark. I believe there's a trademark boot camp on the PTO's website. So not that I'm recommending that you do it pro se. However, if if you have the wherewithal to kind of like take some time with it and learn, I think the PTO and the government generally has taken a lot of efforts to, make all of this accessible. You're the taxpayer. They really work for the taxpayer. So I think they've done a pretty good job there. But it's uspto.gov. Yeah, I'll work with Ala, or I'm sure Ala just knows all the links, but
I can do that.
we could post links.
Yep. And the follow-up question is, registration of the trademark, is it 5 or 10 years?
Renewing the registration is year 5 and 6. So the renewal is ripe at year 5, but you have until the six-year anniversary of the registration. So yeah, just the 365 days between the 5th and 6th anniversary. You need to file a small package of paperwork that says you're still using the mark in commerce and it is the mark you originally applied for. Oh, I also didn't mention that, just real quickly, I will say that we as Solar Flare, we can register our trademark before we even sell any of the sun power tiles. There's a pathway to register a trademark before you even sell anything. So there's really no reason to wait. I think sometimes people like want to sit and wait, but one thing to know about IP, it's like almost always first in time, first in right. So you don't want to let a competitor beat you there. You want to get there first, and there's mechanisms to do that. If there's more questions, if not, I'll move on, but I could pause here if there's more questions.
There's a question here about a patent, but maybe if you're going to cover patent protection, maybe we can address it then.
Yeah, let's put a pin in that because next slide
Perfect.
is about patents. So Solar Flare. So we've protected our brand, or we have a strategy to protect our logo and the brand name. So we sorted that out. We've got tactics in mind how to get there. Next is we're selling the sun power tile. So how are we going to protect that? How are we going to make sure competitors don't just come and make something that's functionally equivalent but a little bit different, or just wholesale copy it? The mechanism under federal law to do this is patents. So a couple things you should know about patents and patent strategy. The first thing is I'm sure, have heard of provisional patents. Provisional patents are the flip side to non-provisional patents. So provisional patents are never substantively examined, whereas non-provisional patents are. And the real function of a provisional patent is to hold your filing date. So on the last slide, I said generally first in time is first in right. That applies here. The US is a first to file jurisdiction. So that means if Ala and I both invented the sun power tile, but she filed today and I filed Friday, she wins. She'll get the rights, and my application would be rejected as either like not novel or obvious in view of hers. So you got to get there as soon as reasonably possible. You got to get your application in as soon as it's practicable. The way you do that is by filing a provisional patent. So I think I'm trying to remember the fees. I'm pretty sure for a like micro-sized startup size entity with like less than 234K annual revenue and less than 4 patents owned, I believe the filing fee is $60. The provisional patent is not required to meet any formal structure. You can simply disclose everything you can think of about your invention and file it with the fee. It will hold your filing date for 12 months, which is to say you have 12 months after filing a provisional to file a non-provisional. And as long as you claim the benefit of the provisional in your non-provisional, it's like the patent that I file in May 28th, 2025. As long as it claims the benefit of the provisional that I filed May 28th, 2024, it's like I filed the non-provisional on May 28th, 2024. So that's the benefit. But don't go past 12 months because you lose the benefit. The benefit only lasts for 12 months. You can file a follow-up provisional, but again, never examined. So just be mindful of the timing. What else? So that's provisional versus non-provisional. Then there's utility versus design. Utility patents protect the way that the SunPower tile works. It can protect the manufacturing process. It really protects what it does versus a design patent protects how the SunPower tile looks, the ornamental features of the SunPower tile. Think about the iPhone. The design of the iPhone is really valuable, right? Other Apple sued Samsung for copying the design and won a lot of money. So both utility and design patents are strategically really valuable, very important assets. Little question here. I know the structure makes it hard, but if you just want to jot a note to yourself or drop it in the chat, the question number 1, which non-provisional patent would cover our SunPower tile? I'll give you guys 10 seconds. Utility, design, or both? And the answer is both, because you can protect the way the SunPower tile looks. You can also protect what it does. We said it was highly efficient. It's like very durable for any type of weather condition. So there's novel aspects in both the design, or ostensibly in both the design and the way it works. You could file 2 different patent applications, non-provisional patent applications under the utility patent law and the design patent law, and get 2 different patents that give you 2 different scopes of protection. So to take that a little bit further, let's say that our non-provisional utility application discloses a software algorithm that tells the SunPower tile, or is like really the secret to how the SunPower tile is so efficient in terms of like power generation and consumption. So what about that? What's our strategy for protecting that? So we'd have to disclose that in a separate application. The PTO's rule is basically 1 invention per 1 application. You pay an examination fee when you file your application, and they're like, well, we're only going to examine 1 invention for this 1 fee. So we could file a separate utility application, but it's not guaranteed that we get it. Software is also subject matter eligible for copyright. I don't have a copyright slide, but I will just quickly review copyright here. So copyright subject matter eligibility is original works of authorship, fixed in a tangible medium. So as it applies to software, the software is your original code, right? It's fixed in a tangible medium. You like write it down or upload it to whatever software platform. So you could print it out, right? You could print out the text file. You could file that with the Copyright Office. It's copyright eligible. Copyright registration is really accessible. There's an online form, there's circulars and tutorials to help you file it. I believe the filing fee is between $60 and $85. It depends on the type of work. I think most people think of copyright, you know, in the context of movies or songs or books, but there's also copyright eligibility for software and other creative endeavors that don't, necessarily show up on HBO. But that is to say, there have been two examples here of concurrent eligibility. So utility patents and design patents, that same SunPower tile has the concurrent eligibility for a utility and design patent. And here also software has concurrent subject matter eligibility. So, as you're thinking through how to amass assets strategically, just be aware that there may be some overlap and you're not necessarily just talking about like one thing versus another thing, and that's it. We could do the patent question. I only think I got like 3 more slides left. We could do the patent question here, Paula, if you want, or if I haven't answered it.
Sure, yeah. So it's more of a generic question, but it would be helpful for everyone to hear. What is stopping other companies with improving upon or stealing your patent design? And what's once it's in the patent system, how do you handle that?
Yeah, there is, so a design patent. A design patent protects the ornamental features of the invention. So the iPhone design patent, it protects the ornamental features of the iPhone. There's a way that they drafted it where, there's a iPhone Max versus like the smaller screen. There's a way you draft the design patents that captures just like changing the scale bigger or scaling down. Um, patent infringement depends on um, the, sorry, I'm trying to distill this to a couple words. Patents protect you against the same thing you have invented and also obvious improvements and also functional equivalence. So if they found another way to solve the same problem that essentially works on the same mechanism that your invention does, then that is arguably within the scope of your patent protection. Same kind of thing as the Trademark Law Office examination of applications. So the patent also has a core of patent examiners who, when a new application comes in, there's an office that looks at it to make sure it meets all the formal requirements for a non-provisional. And but the non-provisional has more requirements. So they'll examine it for formalities. Then it will go in the inbox of an examiner, and they will look at that application to see whether it passes legal muster for the application to become a non-provisional utility or design patent. So, they're looking to see, is there another invention that claims the same aspects as this one? Is there obviousness is kind of effectively like, will invention A, B, and C, if I put all of their pieces together, can I get what you disclosed in your application? If you can, and some other requirements are met, then your application may be obvious in view of the examiner. And like I said, functional equivalence. So the the passive way is that once your application and your disclosures in a pipeline, it's effective against everyone else. No one else can like copy yours, and the examiner can also leverage yours in view of similar tech to render another application obvious. Yeah, I think maybe that's it. I didn't talk about patent term. So design patent term is 15 years, and non-provisional patent or utility patent term is 20 years. But if the passive mechanism doesn't work, there's some government channels, right? Like there's always federal court litigation, and the International Trade Commission also has authority to block imports that infringe US IP owner rights. So yeah, there's a process with the in the ITC to do that. And then the marketplaces like Amazon, Amazon, eBay, what else? Facebook Marketplace, they have IP policies as well. So if you report an infringing product, they have their own internal review system, and they can delist sellers for IP infringement as well. I hope that answers.
Yeah, it should. Thank you.
Okay. All right. So we're rounding the bend. So here's another little we'll add on for a hypo here. So let's say you're the CTO, right? The CEO's like, y'all have a difference of agreement. He leaves. He starts a competing venture. The FTC, just for a background, the FTC proposed a rule that would effectively kill non-compete clauses in employment agreements. So you just already updated your employment agreement with this employee. So they walk. They took an email list that belonged to Solarflare with them, and now he's trying to solicit customers. So what do you do? Just I don't know. No one can just unmute themselves. So the answer is that email list likely qualifies as another version of intellectual property, which is a trade secret. So the definition of trade secret under the Federal Defend Trade Secrets Act is essentially business information like this email list or customer list, proprietary information that's generally not known to others, but that, the venture derives an economic value from. You're entitled to use the Defend Trade Secrets Act if you have this one proprietary tech, someone takes it, and you have taken reasonable measures to protect the secrecy of said information. So that's like password protection, that's two-factor authentication, that's restricting access, labeling files confidential, things like that. These little formal things, but they end up making a big difference. They're accessible to everyone, but they're kind of things that you may not think to do, but they make a big difference and give you another avenue to enforce your IP assets. They are, since you have to keep this information secret, there's no like registry, there's nothing to file. To meet the definition of trade secret, you just have to, it has to be a proprietary secret, and you have to take reasonable measures to protect the info. But after that, you could avail yourself against this person of the Federal Defend Trade Secrets law. So you'd have to sue them in federal court, but likely it would be enough to say like, hey, look, cease and desist, or else it's going to be over for you in court. that's probably enough to get them to stop. But if not, go forward. The damages can be money damages, an injunction, which is you can't do this anymore or you have to do this. And also attorney's fees in some circumstances are within the recovery, within the scope of recovery, recoverable. Just the last substantive slide here. I just quickly wanted to talk about like who actually, you've amassed this portfolio of assets, who actually owns it. For example, if Allah invented the Sun Power title, she filed or we filed as Solar Flare and named Allah as the inventor. If we didn't name Solar Flare as the assignee, Allah as the inventor would be the de facto owner. So to really own these assignments, you have to make sure that you record, to actually own these assets, you have to make sure that you record an assignment. The PTO has a assignment recording division. The trademark office does as well, although you can just record the assignment in the application. But you have to make sure that you record the assignment. In the case that you want investors, when they do due diligence, they're going to want to see the clear chain of title, especially if you're basing the valuation of the venture on those IP assets. You're going to have to represent to the acquirer that you own them. And just having the assignments together, demonstrating that clear chain of title will make everyone's life easier, will make the due diligence process go faster. And also, just piggybacking off of the valuation thing, I think I did my bullets out of order, but the value of these assets shows up on your business's value sheet, or business's balance sheet, and justifies your evaluation of the business. Patents, trademarks, copyrights are generally recorded as intangible assets, but also the, like brand loyalty to your business can show up as goodwill. It justifies the difference in price from the, the tangible things owned by the business, the assets, the cash, and what actually gets paid. The goodwill represents like the brand loyalty and the value of the brand. And the other thing I wanted to mention is, we talked about like bringing suit in federal court as an enforcement mechanism. We talked about renewals. We talked about these filings. Some are more expensive than others. All these fees are tax deductible as expenses incurred in the ordinary course of business. So just keep in mind with that as well. Like these investments, you can recover them when it's time to do the tax reporting, or at least they'll offset the revenue of the entity. And with that, we can move into the formal Q&A.
Great, thank you. Thank you, Greg. Here's a first question. What is the cost for applying for trademark, patent, copyright, and the estimated cost of working with an attorney on any of these projects?
Yeah, okay. Copyright, I think it depends on the complexity of the registration, but like I mentioned, it's pretty accessible. It's something that you could do pro se if you're, startup that doesn't just have capital to you have to make decisions about how to spend limited capital. I think attorney fees may start around like $500 for a copyright registration. Trademark. Trademark registrations, the government's filing fee, so they apportion their filing fee by each class of goods and services. I may not have mentioned this in my slide, but solar flare. So solar flare is in a goods class because we have the sun power tile, right? So we have that good. And then we're also we could be in a services class too, because maybe we send people out to install as well. So the trademark office divides these marks into classes of goods and services, and the fee that you pay when you apply depends on how many classes of goods and services you claim in your application. So the application fee is $250 per class of goods and services. I think attorneys' fees probably run anywhere from maybe 1,000 to like 2,000. My firm charges 1,850. Yeah, for like search, filing, and non-substantive prosecution. So it like packages fees together. I try to bundle fees as much as possible because I work with a lot of small business ventures, and that's what they kind of want to see. But um, it varies. And then for a patent, I think a provisional probably will run around like 5,000, 4,000, 5,000. A well-drafted provisional should be the foundation of the non-provisional. My office and some other colleagues, I know they charge around like 7,000 for the conversion to the non-provisional. And for prosecution, it varies, but flat fees are probably between like 2,500 and 3,500. So I think all in a patent can run probably like 12,000 is a good planning budget for a patent. There are, like I mentioned earlier, there's some sources of non-dilutive funding. There's also TEDCO. They invest in ventures to help them absorb some of these expenses. I know some attorneys do like a subscription model. So you can kind of like pay over time or as you accumulate revenue and sales. Okay, I hope I got everything, everything that was asked there.
Yes, and I posted the links to the trademark on USPTO, and also if you go there, there's also information about patents. And US copyright is registered with a separate office. Do you want to talk about that, Greg?
Oh, sure. Yeah, copyrights are registered at copyright.gov. It's a website. It is the Copyright Office is actually within the Library of Congress. It's like a sub
Yeah.
office within the Library of Congress, but it's a very accessible application. I think if you can navigate it within a couple hours. The only tricky thing is that when you file an application, there's a written part, and then you have to submit a specimen of your work to accompany the application. So I believe you pay first and then submit the specimen after that. But it's kind of weird because you do the application. It's like, okay, do you want to proceed and pay? And you're like, wait a minute, I haven't uploaded anything, but it will follow. So take heart. But yeah, the PTO is patents, trademarks, Copyright Office, copyright.gov is copyrights, and trade secrets, file nothing, keep them secret.
Thank you. I don't see any other questions, and we're actually exactly at time. So this has been perfect,
Oh, right.
perfect time.
I needed another hour the first time.
Absolutely. So yeah, thank you so much, Greg. Anybody having any questions? There's a link to get in touch with Greg. So please feel free to reach out to him or send me an email and I will forward it to Greg. Again, thank you so much, Greg. This has been fantastic, fantastic session. Lots of great information. Thank you so much to everyone who attended and especially those who stayed to the end. Have a great day and now we'll follow up with the link to the video.
Okay. Thanks, Ala. Thanks, everyone, for your kind attention. Have a good one.